Good morning. It looks like everybody needs to unmute your microphone.
Good morning.
Good morning.
Are we expecting anyone else? Ms. Vanzi, are you expecting anyone else?
No, it's just Miss Berger and myself. Thank you.
All right, thank you. Is everyone ready to proceed?
Yes.
All right. We're here this morning to see what you all think you need to do in order to get this matter resolved. Have you, Ms. Vanzi and Mr. Woods, have you conferred with each other and come to any agreement about what discovery, if any, needs to be done?
We have not, Your Honor. And just for the record, Zach Goodrich is General Counsel Intervenor for the State Ethics Commission. We have a draft scheduling order, which is mostly boilerplate language with some dates thrown in there. But beyond that, we have not had the time to confer with Ms. Berger or Ms. Vanzi.
Right. Well, I apologize. I called you by the wrong name. You're Zach Goodrich. Maybe I should have counsel enter your appearances for the record, and I don't want to have to worry about that.
Sarah Berger for New Mexico Families Forward, Your Honor.
And Linda Vanzi also for New Mexico Families Forward.
Mr. Goodrich?
Zach Goodrich is Intervenor General Counsel on behalf of the State Ethics Commission.
Okay, so you haven't talked. So during the course of the investigation, which was done by your predecessor, Mr. Goodrich, there, as I recall, there were very limited requests for production and interrogatories submitted, which were not responded to. But I don't recall it. Was there any other discovery? There were no depositions or anything, were there?
Not as far as I'm aware, and as far as the discovery that was proposed by my predecessor in this matter, I'm not aware that any of it was conducted or completed because the stay came and then the litigation ensued from there.
All right. Do you think you need to conduct any discovery before we have a hearing on this matter?
I think it would be fairly essential to get the evidence that we need to prove the claims that had been at issue in the investigation from the beginning. I understand I did receive a message from Ms. Berger stating some problems with the proposed quantity of discovery, I suppose. But I would imagine it's fairly basic discovery of what we need, a handful of witnesses, potentially a deposition, and then some interrogatories and requests for production.
How many depositions are you contemplating?
Oh, one for sure, I would think, but maybe up to 3. But the witness list that we're working off of has, I think, 5 that were set to be called at the hearing originally, but it's still a bit fluid at this point.
All right. Ms. Vanzi, do you intend to take any depositions?
Judge, Ms. Berger is going to respond to.
All right, Ms. Berger.
Yeah, Judge, we are intending to file a dispositive motion. In the order denying our motion to dismiss, you cited the Ethics Commission's position that there was probable cause to proceed only as to the question of whether New Mexico Families Forward refused to disclose contributors. That's the one single question before us. And that, I think, can be decided pretty easily in a dispositive motion without the need for discovery. The commission's position was that when an organization states that it used general corporate treasury funds for an advertising campaign, that was not sufficient, that they needed to disclose the source of that general corporate funds, in other words, other donors. That's an interpretation of the statute, and we believe that we can have that decided. That would either moot discovery or certainly limit the discovery that would be needed should we not prevail on our dispositive motion.
Have As I recall, the facts in this case are pretty much straightforward and for the most part are not disputed. As you state, there's an issue of whether or not you complied because of you're not specifically identifying individual contributors. Have you talked to Mr. Goodrich about stipulating us to sufficient facts so that you can get your motion to file and I can make a decision?
We have not had that discussion. Happy to have that discussion. But again, I don't, even if they don't stipulate, that is the position they took in their findings of fact back in the day, that saying general corporate funds is not sufficient. If they're willing to change that position,
Mr. Goodrich, who specifically are you contemplating deposing?
Mr. Eli Il-Young Lee is top of the list. But if I could just respond to one point briefly, Your Honor.
Okay.
The issue as to whether or not the interpretation of general corporate funds, yes, that is the issue at hand, but at the same time, the evidence that is present in the report tends to show that, you know, New Mexico Families Board was incorporated shortly after, and then there was testimony from, I believe, Mr. Young Lee, and I apologize if I'm getting his name wrong, indicating that there were other sources of funding. And so the evidence tended to show ultimately that it was not quote unquote general corporate funds, which I think is the distinguishing factor here that I think needs to be raised here. Is not just the interpretation, it's the evidence showing that it's not necessarily general corporate funds.
Well, as I recall, and I haven't looked at all these materials in quite some time now, but as I recall, in response to your interrogatories or request for production, Ms. Berger told you that the organization had filed a tax return and that you could probably get the information you were looking for from that tax return. Did you ever, or not you, but you know, if your predecessor ever got that information?
Not aware if they did pull that information, but I have seen the correspondence, and I do agree with Ms. Berger that the information is publicly available. So those would not be included in the request for production.
if I could, Judge, the evidence didn't show, I mean, that was an interpretation of the predecessor general counsel when the affidavit stated that there were no contributors who gave for this campaign. It got interpreted to mean there were other campaigns. I mean, so that's, I just want to clarify that. They filed a report, which is public knowledge, publicly available, that they use general corporate funds. That's what the Secretary of State has on its website. Secretary of State has them as compliant as to that. So they did state that they use general corporate funds. That is how they reported. So how the predecessor interpreted or how they're currently interpreting that affidavit, I don't even think we need to go there. I mean, again, it's the law says you disclose contributors who gave for the campaign. I think we need some guardrails on what that means. Does that mean that general corporate funds are sufficient when you don't have a contributor? Again, if
Well,
it comes out a different way, we would then have a deposition of Eli or, you know, answer some of those questions about other contributors.
well, let
Clear
me
it up, I
ask you,
guess.
if you're willing to share this, what do you, by you I mean your client, what do you think general corporate funds means?
It means that there wasn't a donor who gave money saying like, hey, we want to fund, you know, kind of like in the campaign finance world, we want to fund your advertising campaign. Or you ask someone like, we're going to do this advertising campaign, will you give us money? So similar to and you certainly don't include donors who say, here's $50,000, you cannot use this for lobbying. You know, so that all, you know, that should be off limits. The donor has stated you can't use it for lobbying. They don't expect to be disclosed. And so it has broad First Amendment implications. getting this right, having an organization know before they start doing their protected speech, what they're going to have to disclose. I mean, this is all very vague, and I think we do need that answer. But yes, I believe that someone gave because they wanted, they earmarked the money for the advertising campaign.
All right, well, that leads to another question, but let me ask the question I was thinking about. I assume your general corporate funds come from contributors, correct?
They come from contributors, and oftentimes a funder will say, it could either be an unrestricted gift or it could just be general operating funds to say, like, we like what you're doing, just continue doing it. Sometimes it could be a project specific grant to say, we want you to pass, a clean energy bill at the legislature. And that would be a case where if you started doing ads on clean energy, that would be a donor who earmarked. So yes, I think there's a range of contributors.
But the call them donator, contributor provides, is this all put into one fund and then you spend it depending on what the contributor says or doesn't say?
Yeah, and I don't believe this organization had that, but sometimes a donor might have a restricted fund for a building project or something like that. But yes, otherwise it's all placed into general operating funds. But if NMFF had to spend something, they have to report back to the donor that they spent the money. If it's a project-specific grant, that they actually spent the money the way that it was intended. And again, I don't know for sure which donors required any kind of reporting back, but
yeah, well, it seems to me we might need more information to make this determination. If you want to argue about it and file a motion, we can, but I would be inclined to allow Mr. Goodrich to take Mr. Young's deposition if you think he's the person who would be most knowledgeable about how situation involves general corporate funds versus a specific donor request. Because otherwise, I guess you've got an affidavit from him already. You could file that affidavit in support of your motion, but it still might lead to a request for his deposition.
If Your Honor would allow, I would suggest we have a conversation. And I know you wanted us to do this in advance, but we were planning on filing this motion and staying discovery to have a conversation to find out exactly what would be the most efficient way to get at this answer.
Well, that would be fine with me. You're not talking about a conversation with me. You're talking about
No.
All right. Well, okay, let's do this for now then. Let's we have to do this in anticipation of what might or might not happen. So let's first talk about a hearing date. It doesn't sound like whatever needs to be done doesn't involve taking a lot of time. So does anybody have a suggestion about a hearing date? We're talking about March, April?
Judge, I am booked through pretty much through June. And I think that if Your Honor ends up allowing the SEC to take multiple depositions and things like that, it's going to be very difficult to schedule that in just the next 2 or 3 months.
Okay. Well, Mr. Goodrich?
I would echo what Ms. Vanzie said, just given the trial schedule that I know that I have, and then just wanted to make sure that there's sufficient time for all those and any work to get done.
All right. Well, I've got plenty of time in my hands. I'm basically retired. So, Ms. Berger, what's your thinking?
Yeah, I agree with both of what they said, and maybe sometime
we better grab
like
Ms.
September
Vanzie.
or
How about a July date? Will that work?
Judge, I think part of it is going to depend on how many depositions you allow. I mean, among other things, uh, our client is, I mean, doesn't exist anymore, right? So we really advocate for a very, very limited amount of discovery here, for any number of reasons, but not the least of which, uh, you know, it's going to get very expensive. 5 depositions is a lot of money, for, an entity that doesn't exist anymore. I mean, we're talking in excess of $5,000 or $6,000 for that.
I understand your point. But I don't intend to allow 5 depositions at this point. I want you all to talk and see if you can agree, and start with Mr. Young and see where that takes you, and then we can go from there.
And July is, at least for me, it's July is fine.
Okay, well, you pick first.
I'm trying to make sure I know I have a week-long arbitration in July, but it doesn't matter. Well, we can just pick the date.
Okay, Ms. Berger.
I would say, I'm sorry. July is fine with me as well. I think mid-July maybe. Let's get past anyone's holiday plans if there's any for the beginning. I don't have any, but maybe the week of the 13th or the 20th.
Okay, Mr. Goodrich.
I was going to propose to Monday, July 20th, for the same reason. Later in the month works better.
All right, Ms. Fanzi, are you okay with July 20th? Did you know when your arbitration is set? You're muted, so I can't hear you.
Sorry. I think it's the week before. I think they're going to torture the 3 arbitrators and send us to Phoenix in the middle of July.
Okay. July 20th work for you, Ms. Berger?
Yes. Thanks.
Okay, so we got that accomplished. So I'm gonna wait to hear back from you all before I make a decision about discovery, because maybe you can figure some way to avoid discovery, but I do the Jim Browning thing. I'm leaning towards allowing at least 1 deposition in this case to give Mr. Goodrich more information about his concerns about general corporate support. But I'll let you talk about that and see if you can reach an agreement. I don't think we're going to need a lot of written discovery. There was 3 interrogatories, 3 requests for reduction. I don't recall exactly what they were, but one of them was obviously asking for financial information. But maybe you can resolve that, or you can get that information from 1 deposition. Motion practice will sort of just follow the state court rules. I can't give you I guess I could give you a deadline, but you'll need to. I mean, are you saying, Ms. Vanzi, that you couldn't attend 1 deposition between now and June?
I can tell you that I am booked every day between now and the end of March. I could attend a deposition in April or May, but Ms. Berger can handle a deposition. So
all right.
I just didn't want to set a hearing date or have 5 depositions that,
Right.
she couldn't handle something. So.
All right, Ms. Berger, are you free in
Yeah.
the next month or so to take a deposition if that's what you all agree on?
Yes.
Okay. So just in my experience, both in private practice and in the bench, it's always better to have deadlines instead of leaving things hanging. So let's do March 31st as the deadline to file motions. Is that okay, or is that too soon?
That's fine.
All right, with you, Mr. Goodrich?
Sure.
Okay. Do you want to schedule another conference after you confer in case you can't agree, or you want to let me know in writing with just an email copying everybody so I can get an order in or whatever?
Follow up with an email. I think that might be the quickest and most efficient way for everyone, if there's no objection.
Okay, well, you all confer and let me know by next Friday what you've decided. And if you haven't reached an agreement and there's still an opposition to taking a motion, then we may have to schedule a brief hearing on it, but I don't think I'll need a motion or a lot of briefing. We can just talk about it. So let me know as soon as you can, and then if there's an agreement, I'll get an order entered. And if there's not, then we'll get together again and have a brief hearing on whether or not you're going to be allowed to take a deposition. But again, in fairness to you, Mr. Goodrich, I think I should tell you I'm not inclined to allow a lot of discovery in this case, a lot of depositions or a lot of written discovery. It doesn't seem like it's necessary. It is pretty straightforward. We just want to make sure we have facts to which there's no genuine issue if we get to that point, so we can decide the case based on somebody's interpretation of the law, which may come down to mine. So, all right, anything else we can talk about this morning?
The thing I was going to note for you, Your Honor, was that the complainant had just joined. I'm not sure if Mr. Castellano has anything to add, but wanted to note that for you.
Okay, yeah, I do want to take attendance, so and I don't see him on my screen, but you're telling me he has joined?
He has. His video is coming on right now, and I think he's getting ready.
Good morning, sir.
All right, good morning. How are you?
Good. I apologize when I copied this Zoom link into my calendar. I was using the old link and not the courtesy copy, so I sincerely apologize. Unfortunately, I probably don't have much to add right now, and I can regroup with Counselor Goodrich to debrief, and please accept my sincere apologies.
Your apologies accepted. If it happens again, you'll be buying donuts for everybody.
I may intentionally do that because I sure do love donuts, so I may.
There you go. Okay, so Mr. Goodrich can bring you up to date if you want to know what we talked about and what we decided. But I need to hear back from the council by next Friday before we can make a decision about how we're going to proceed. So we're going to call it a day, and let me know as soon as you've had a chance to confer and what you agreed or haven't agreed on, and then we'll go from there. All right, we'll be in recess.
Thank you,
Thank you,
Judge.
Judge.